So here is the swoop. The Norwegian fire-farting dragon swoop. All right. Let's get this on the road. Okay. Motions. Motions time. 10 pages. Yeah, that's good. State of Georgia v. Jeffrey Williams et al. Joint motion to exclude evidence. Come now, Mr. Jeffrey Williams et al. Herein after the defense. By and through their undersigned counsel, and hereby file this joint motion to exclude evidence in the above reference case. In support of this motion, the defense shows as follows. The defense respectfully requests this honorable court to exclude photographs in Dropbox 59 Antonio Sumlin for the reasons set below. Photo 1. Photographs 4 through 9 of 36. These images, based upon the fact that the unrelated firearm should not come into evidence pursuant to these case law or these rules, OCGA. Yeah, if guns aren't related to a specific crime, then they are only used as bad character evidence and should not be allowed. Number 2, photographs numbers 1, 2, and 3 show a red bandana and are cumulative, and hence only one photograph should be admitted if same passes OCGA these rules. And this is the footnote here. As ordered by this honorable court on Friday, September 13th, 2024, Friday, the defense is not targeting any body camera or recorded jail calls contained in this portion of the discovery that is being analyzed, as the prosecution was ordered to specify which part of each body camera and recorded jail calls the state wishes to introduce into evidence to present to the jury. Then the defense will voice objections, if any, to those segments. If this honorable court decides otherwise, please advise, and the defense will follow this honorable court's order instanter. Okay, number 3 here. Photographs 10 through 36 are purported to be Mr. Sumlin's body with artwork, and same are cumulative and hence prejudicial, if relevant at all. Thus, the defense asked the same to be limited, if any are admitted. Number 2, the defense objects to the following evidence related to Ms. Latner's purported testimony being admitted at trial. 1. Ms. Latner's March 13th, 2022, report and 911 call from caller Tiffany LNU violates the confrontation clause, as well as hearsay, as the communication is not concerning an ongoing emergency. Yeah, this is a much later 911 call that may or may not be even related to this case. 2, March 14th, 2022, report ending in 1882, page 304, reads user Chris Butler as same is supposed to be images of a license plate reader and are not self-authenticated, and adds additional information that is used for prosecution and thus violates confrontation clause without a proper witness being able to cross-examine by the defense. Yeah, images of a license plate reader is second-hand information, and they need somebody to testify about this in order to be able to cross-examine. It should not be just admitted as evidence. Number 3, March 17th, 2022, SOS Channel Pursuit. The defense objects to the admission of this file in its entirety, as same is cumulative, as the officers involved in this incident will presumably testify at trial. In the alternative, if this audio file is admitted, the defense specifically object to the playing of this audio from start to 1.30 and 15:10, which deal with a different issue involving an animal and hence must be excluded pursuant to these rules. Moreover, the defense objects to references of a possible 69. I mean, it would be interesting to... I don't think they mean that kind of 69. At approximately 1330 and 1345, a same is a testimonial statement in violation of the confrontation clause. They cite case law. Additionally, at 1130, there are two references to both subjects being quote-unquote armed and dangerous, and same must be excluded under OCGA, these rules. And it violates bad character evidence. Yep. At 1222, there is a reference to one person throwing in a bag. And 1245, there's a discussion about whether said bag was located. This is testimonial and violates the confrontation clause. At 1305, there is a reference to Mr. Shannon Stillwell, which is testimonial and violates the confrontation clause. At 12 and thereafter, this audio must be excluded because of the quote-unquote ongoing emergency was over as law enforcement apprehended the suspects. Yeah, the state is trying to just admit this without anybody actually testifying to it. Act number 124 from Mr. Sumling, ending in C6D4, if admissible, needs to be redacted as same is redundant. The defense position is that this purported exhibit must be excluded under OCGA, these rules. I don't know what that is. Act number 124 from Mr. Sumlin. I assume this is an overt act of some sort, which some of these overt acts apparently consist of just a piece of evidence. Act 126 7AC and Act 126 627 for Mr. Sumlin are photographs purported to be shirtless images of Mr. Sumlin displaying tattoos, which is cumulative of previous photographs that the state wishes to admit into evidence at the trial of the case in violation of these rules. If this honorable court admits over objection, the defense asked for the statement, quote unquote, chasing that money, but my past chasing me, to be excluded from coming into evidence against the criminally accused on trial, as same does not further any supposed conspiracy. Okay, it's a song. Again. The defense respectfully requests any and all commentary be removed from Act blah, 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 blah. That, in my opinion, goes to the prosecution adding information in the evidence. Act 73E55 is cumulative to a video that the state is attempting to admit into evidence and supposed statements by Mr. Sumlin. On the bottom, do not further the conspiracy. Moreover, Act 73 RP replay is the video of Act 73E55 with audio, and hence Act 73E55 should not be admitted into evidence if Act 73 RP replay is admitted into evidence, as same is cumulative. Moreover, this purported exhibit is on a loop and should not be played more than once if admitted over objection. Also, the defense respectfully requests the removal of Mr. Sumlin's writing. Yep. Act 171. There are two shots. Here comes my pronunciation again. There are two shots that appear to have been made by an unknown party, detailing supposed telephone calls and their duration, and unless the foundation can be shown that they're for the original records from which these summaries were made, the defense objects. If admitted over objection, this summary chart should not be permitted into jury deliberation rooms based upon the continuing witness rule, as well as not original evidence but is testimony. So summary, that is more or less like the, what do you call it? The what do you call it? Well, all the pictures that was excluded because it's summary. You need the actual evidence, not the summary. Summary evidence is just bad taste. The defense objects to the audio call located at this act, which contains Christian Eppinger and an unknown female. Under OCG blah, blah, blah. balancing test, waste of time, confusion of the issues, prejudice substantially outweighs any probative value. The defense objects to text regarding Lucci based on hearsay, relevance, and confusion of issues and cumulative. Okay. The defense objects to the audio file labeled October 17th, 2024 in folder 61. Freddie Whetstone. Interview with Freddie Whetstone, which consists of the content of Mr. Whetstone's interaction with law enforcement. Same must be excluded as it violates the confrontation clause and hearsay under this. Freddie Whetstone, I don't think he's on the witness list. So yeah, out with it. Out with it. No kerosene. Scrapbooking. Yeah. The defense objects to admission of report packet dated March 13th, 2022, written by Officer Steve Dadia, as same as confrontation clause violation, as well as hearsay, as it is not dealing with an ongoing emergency, but the report of a past crime. Okay. The defense objects to the August 16, 2022 report authored by Officer Ellis Anderson, as same is a confrontation clause violation, as well as hearsay, as is not an ongoing emergency, but report of a past crime. The defense objects to S. Davis crime scene report, as same is a confrontation clause violation and should not be introduced into evidence or shown to the jury without the witness present for cross-examination. Yeah, so S. Davis seems to be an CSI that is not on the witness list. The defense objects to the timestamps located on the still photographs from a video located in folder 65. Detective Grimsley's photos investigation concerning Mr. Drink's investigation, absent a foundation being laid by the prosecution establishing that these are true and correct timestamps. Yeah, remember today when the prosecution argued that, do you really know that these pictures were taken on April 28th, when Mr. Stilwell apparently didn't have dreadlocks? And then they questioned, and now, yeah, it's so hypocritical. The defense objects to cumulative photographs taken from the autopsy located in folder 73, Dr. Melissa Sims Stanley. The defense wishes to limit the number of autopsy photos. I believe they have gone through this, and the judge allowed 3 autopsy photos. The defense objects to photo number 26, a handgun presumably seized out of 2830 Waters Road by Officer Mercury on or about March 16th, 2022, located in Witness 74, folder March 16, 2022. Incident photos as this firearm is not linked to any of the criminally accused on trial and has no nexus to any of the charged act, whether counts in the indictment or overt acts related to count 1. Yeah, so the state only wants to look at this person. That person had a gun. Wherefore, the defense respectfully requests a hearing on this joint motion, and at the conclusion of same, ask this honorable court to grant the above requested relief. All right. Well written. A bit technical, but very, very well written. All right. Next one. Hold on here while I go up to the next one. This one. Can you all see? Let's make it bigger. In the Superior Court of Fulton County, supplement to joint motion to exclude evidence. Okay, so this is a supplement to the prior one, I assume. Come now, Mr. Jeffrey Williams et al., herein after the defense, blah, 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 blah. The defense respectfully requests this honorable court to exclude photographs in Dropbox 59, Antonio Sunny, for the reasons set below. Photographs 4 through 9. Okay. Based upon the fact that the unrelated firearm should not come into evidence. Photographs number 1, 2, and 3 show a red bandana. Didn't we already read this? Oh, here's the supplement. On Monday, September 16th, today, The defense filed a joint motion to exclude evidence. This supplement is filed to add paragraphs 17 through 27. Okay. Let's find those 17 through 27. Here, okay. Here are the supplement. There are 2 audio files labeled this, locating in Viverito file under Act 171. Both are duplicates, and also duplicate of a call that is located in the Antonio Sundin folder. Yeah. Duplicate, I mean, yeah, that should be a no-brainer. The 2 search warrants itemized should not be displayed to the jury or come into evidence. Comprehensive Report 2022 is a confrontation clause issue and is objected to by the defense. Okay. The defense objects to a Cash App document based upon foundation and relevance. Yeah, the state needs an actual person testifying. Without that, it should be going away. Mr. Eppinger's phone affidavit and search warrant should not be entered into evidence in any way or shown to the jury in any way. Mr. Eppinger is a witness. No, he's not even testifying, if I remember correctly. And I don't think Mr. Eppinger is charged. I don't remember. You all tell me. Number 22. The defense objects to the gang member profile of Mr. Sumlin as well as Mr. Eppinger as same is confrontation clause issue and should not come into evidence or refer to whatsoever. Gang member profile. So gang expert testifying about something previous gang expert has already testified to. 23. Image 5167 appears to be irrelevant and no probative value. And dealing with Miss Brown is irrelevant to the case at bar, and the fact that Mr. Sumlin is followed by other people that may be involved in this case, that connection has already been proven, and hence same is repetitive and should not come in. Oh, Eppinger got severed. Okay. Records zip your file gives a file not found error, and thus the defense cannot voice an objection since we cannot open same. Yeah. Verizon exigent numbers ending in these 2 numbers should not be entered into evidence. Okay. 26. Investigator Viverito, Act 180, Roy and Rodelius contain conversation by a person similarly in a prison that would fall under hearsay without an exception, and it is hearsay and not non-hearsay, and same must be excluded. So it's a jail call, apparently. Investigator Viverito, Act 96, Jeffrey Williams discovery. 1. The defense respectfully requests the redaction of all commentary under the host, but include that it is posted on the shade room. Yeah, this is probably commentary from whatever, from Investigator Viverito. He can't add commentary and also present that commentary in the evidence as evidence. It needs to be removed. Okay, that was the supplement. What's next? Motion in limine number 56. Let's see here. Dun, dun, dun. Motion in limine. There, I need to have a quick drink here to moisten up my vocal cords or something. By the way, folks, have you hit that like button now? Hit the thumbs up. You know I deserve it. You know I deserve it. Okay, motion in limine number 56 comes now. Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this motion in limine number 56 to exclude any confrontation clause testimonial hearsay as well as statutory hearsay evidence concerning information obtained from the investigation by law enforcement on or about April 28, 2015, involving Miss Battle, and or any other supposed shootings for which the alleged victim or declarant are not called as a witness to testify at trial in the above referenced case. In support of this motion, Mr. Williams shows as follows. Well, Mr. Williams is innocent of all charges in above referenced indictment. Based upon information and belief, the prosecution is not calling witnesses, supposed victims from alleged drive-by shootings that occurred on or about the early morning hours of April 28th, as well as other supposed drive-by shootings. Yeah, they have referenced these supposed drive-by shootings, but no victims, no witnesses. I mean, the gang experts have only talked about it. Mr. Williams again places in writing his objection to the prosecution attempted to elicit any testimonial statements and or hearsay statements from any law enforcement officers, whether responding on the scene or supposed gang expert or civilian witnesses that do not have any personal observations and personal information. Yeah, I would assume so. If they can't lie the foundation, then it shouldn't be testified about even by gang experts, in my opinion. And motion in limine number 57 here. Let me just pull that up. There it is. Make it bigger. Motion in limine number 57 comes now. Mr. Jeffrey Williams, blah, 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 blah. Shows as follows. Innocent of all charges. On Monday, September 16, 2024, the state called Verizon Wireless Records Custodian as a witness at trial in the above referenced case. This witness could not verify the contents of the text messages contained in State's Exhibit number 1TT, and thus Mr. Williams respectfully requests this portion of this exhibit to be excluded. Yeah, that was what we were just talking about before we went into this cluster F at the end of the trial. And I would assume that all of them has good foundation, all of these motions and motions in limine. But what will Judge Whittaker do? Help the prosecution, I assume. And definitely allow the supposed gang expert to testify about what they believe, which is insane. Judge Whittaker needs to hold the state accountable. She has to. She cannot keep punting it to the appeals court. She has to. She should. She probably won't, but she should start acting as a gatekeeper, not a friend of the prosecution. All right. Oh God, it's 11:30 p.m. where I am. And yeah, I need to go to bed because my alarm clock goes off in 5 hours. So, thank you all for showing up, folks. Thank you for allowing me to try to translate this trial for you. Thank you, guys. And remember, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. So that's it for me and Mr. Jingles for today. I will see you all tomorrow. I don't know when I can start stream, but hopefully you will show up. And so, everybody, see you tomorrow. Okay? Bye-bye.
Gavel cracks, breaking backs, twist the facts, yeah. Rotten core, buried deep, justice cheap, hell. Crooked smile, sneaking trial, deception, vile man. Power trip, crooked grip, lose your grip now. Symbol of greed, fall from the steed. No more lies, mask, disguise, greed ain't no creed. Gave the judge from the bench today. No more lies, corrupt decay. He ain't the judge, watch him sway.